You have to show 3 elements for defamation, the tort of defamation. They are that there is a defamatory matter, that the matter has been published, and that the plaintiff has been identified. Next week, we'll be looking at defences and remedies. So who could be a plaintiff for a defamation matter? There are certain classes of people who are capable of being defamed and thereby of suing for defamation. Generally, living people can sue for defamation, but only the living person who is actually defamed. People who are connected to them can't sue on their behalf. And people who are concerned that their friend has been defamed can't sue for the damage that they perceive and their sense of being aggrieved. They can only sue if they personally are also defamed in some way. For the same reason, dead people can't sue. Section 10 of the Defamation Act clarifies that. This is a tort which relates to the damage done to a person's reputation so that they are harmed as they move through society by the lowering of esteem in the community. A person who is dead is no longer moving through society and being affected by the esteem or lack thereof held by the other people in their society. So a dead person can't sue for defamation. That also means that their estate can't sue, their executor can't sue on their behalf, etc. Having said that though, living people who are connected to the dead person and who are defamed via the defamation of the dead person, the alleged defamation of the dead person, could potentially sue if their own reputation is being damaged. So if, for example, someone says that a person who's passed away was a mafia don and implies that their family are connected to the mafia in various ways by connection to the deceased, then the living people would also be able to sue because of an implication, if it was untrue, that they were connected to the mafia, a criminal organisation. However, the dead person could not sue and you couldn't sue on their behalf. And the final class of people that the Act makes it very clear that can't sue, legal people, but not real people, are companies. You'll see when you do corporations law that a company is technically considered a legal person. They have the right to sue and be sued, to own property, etc. What they don't have though is a personal living reputation. That is a reputation which harms their movement through society. The company may have their brand damaged, and there are a lot of remedies for that in law, including consumer law, passing off that we've already looked at, various torts relating to malicious falsehood, and so on, but not in the tort of defamation. There are, however, a tiny category of companies that can sue. You'll see that Section 9 rules out corporations generally from suing by saying that a corporation has no cause of action for defamation in relation to the publication of defamatory matter about the corporation unless it was an excluded corporation at the time of the publication. So what is an excluded corporation? It's either a not-for-profit organisation, the objects for which it is formed do not include obtaining financial gain for its members or its corporators. Corporators are people who have created the corporation. How do we know this? You'll see when you do corporations law. Basically, when you set up a company, you have a chance to create objects for it, the reasons for its existence, and that becomes part of the registered documents when you create the company if you do a list of objects. If you want to create a not-for-profit organisation, this is where you do it, part of how you do it, and you actually list that it is not intended to create a profit. So that's how you tell for that one. The second category is a company that employs fewer than 10 persons and is not related to another corporation and not a public body. That means a very small company, fewer than 10 employees. It can't be part of a broader web of companies, so it can't be owned by another company. It can't own other companies. It can't be otherwise related to other companies. It has to be a small individual company with very few employees. Basically, this protects small business reputation, and it must not be a public body, so it must not be owned by a government or part of a governmental corporation. So what do we mean? Not-for-profit is relatively easy. We look at the objectives. Fewer than 10 people is a matter for the corporation to prove. If you look at the case of Born Brands Proprietary Limited and Nine Network, this is a good example of that. At first instance, Born Brands did not show it employed fewer than 10 people in its original trial. What had happened was the Nine Network, its Today Tonight program, ran a teaser talking about the fact that baby wedges, that is wedges of foam covered in fabric, which were intended to go into a baby's bed and actually intended to keep them safe while they sleep by propping them at a safe angle, had allegedly killed a number of babies overseas through, unfortunately, causing smothering and other hazards for the sleeping baby. As the Nine Network was airing their information about this, they showed a number of images of these wedges, including one by a New South Wales company, Born Brands. It was a very small company run by a couple of sisters. They sued for defamation. The court said, the judge at first instance said she wasn't satisfied that they had shown they had fewer than 10 employees. She also explored that employees could include people who were not full-time on the payroll and did some work for benefits other than direct employee benefits. On appeal, the court looked at that and they actually did decide they were satisfied that there were only 2 employees, but that was partially about the wording of the New South Wales Act, which is slightly different to ours. It's possible that employing persons rather than having 10 employees, which is the New South Wales wording, may mean that that could include the activities of persons who are not technically employees in Queensland. They talked about that sort of wording. I will let you know that Nine Network was still found not to have defamed Born Brands, partially because of defences of truth and public interest, which are defences we'll look at next week. Another type of body that cannot sue in defamation are elected authorities. The case of Ballina Shire Council in Ringland is authority for that. What happened in that case was that Ballina Shire Council was looking at allowing various developments. Ringland, and that included various sewage works. Ringland had alleged that they were allowing raw sewage to escape into the ocean, which of course was a huge problem for somewhere like Ballina, which is in part a holiday destination. Ballina sued Ringland over these allegations, but the court held that the conduct of an elected government body should be subject to public criticism. It's very important that people be able to debate the activities of their elected representatives and of their government bodies, unrestrained by a threat of being sued for defamation. That the proper running of government meant that governments had to be answerable to their constituents and their criticisms. Now, Ringland's criticism turned out to be untrue, even if Ringland genuinely believed it at some point. But the court was saying that the remedy for a situation like that is for the public body to publish the truth, rather than to try to stifle criticism through the use of defamation actions. And they said a public body, and their rule that public bodies can't sue, would include local governments, other governmental bodies and public authorities more generally.